Okay, in this video I want to take a look at judicial review in Ireland. Judicial review is something that I haven't had much experience with, but from time to time people come to me looking to bring some sort of judicial review. I'll have a look at it in this video and look at the essentials. Judicial review is a collection of remedies of the High Court and Supreme Court. It gives these courts the power to declare that legislative and executive actions are null and void if they are contrary to the Constitution. There's an element of public law about a judicial review, so there must be that public law dimension. Two criteria are applied to test this public law aspect. One is the source of power that is being challenged based on statute or delegated legislation. Two, if so, what is the function of the body whose decision is being challenged? So this would not be appropriate in a private law situation where you may be in an employment situation or you may be involved in some private contract with somebody else. Judicial review would not be appropriate. There must be a public law element to it if you're bringing a judicial review application. Core aspect of judicial review is the power of the High Court and Supreme Court to exercise supervisory jurisdiction over the legality of decisions of the district and circuit courts, public bodies, tribunals and related persons. The courts, it must be noted, are not concerned with the merits of the decision taken. They are only concerned with the manner in which the relevant body has exercised its decision-making power. For this reason, it is worth noting that it is not an appeal process. It's to do with the way that the public body has arrived at its decision and whether constitutional rights have been affected. So the whole question of natural justice or constitutional justice is important. It's a central tenet of common law and the Irish Constitution that a public body is to comply with the requirements of fairness in its dealings. Fairness is a fundamental component of natural or constitutional justice. Thus, lack of fairness, if that occurs, is a ground for judicial review. Other grounds for judicial review include reasonableness or lack of it. In this context, reasonableness is the common sense and fundamental reason being applied to a particular decision and arriving at a decision making or engaging in a decision making process. Another ground for judicial review is legitimate expectation. This may arise where a promise has been given by a public body or where a regular practice exists which the claimant can reasonably expect to continue. That is, custom and practice. Another ground for a judicial review application is proportionality. That is, where restrictions are imposed by legislation prove to be disproportionate vis-à-vis a person's constitutional rights. So this would also give grounds for a judicial review. It's important that the person who is bringing the application for judicial review must be able to show sufficient interest. In other words, if they don't have interest, if they're simply a sort of a nosy parker and don't have sufficient interest, then they won't be allowed to bring their judicial review application. The remedies then arising from it, the first thing to be aware of is that judicial review is a discretionary remedy, and the courts, the Supreme Court and the High Court, have a great degree of discretion in this regard. One of the remedies is certiorari. This is generally used where a public body has acted beyond its powers or contrary to its duty. Prohibition is another remedy. It is sought to prevent a public body from acting ultra vires, that is, beyond its powers, and is similar to looking for an injunction to prevent a public body from taking a certain course of action. Mandamus then is an order from the High Court directed to a public body to perform a duty of a legal nature. That could be, for example, in relation to providing accommodation for a family or for a child or for somebody in custody or something of that nature. Section 50 of the Planning and Development Act 2000 also provides for a judicial review type procedure in planning matters and decisions of a planning authority. It's more restrictive than the ordinary judicial review because the application must be brought within 8 weeks of the decision that is being challenged. Hope you find this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, simply hit the subscribe button down below and click on the bell, and you'll be notified when a new video comes out. Thanks for watching.